Hello and welcome to the Eversheds Sutherland and Milliman joint webcast, Legal and HR Considerations for Post-Merger Benefits Integration. If you have a question during the webcast, please submit them via the Ask a Question text box on your viewing console. A copy of the presentation will be sent to all attendees via email following the presentation. I will now turn it over to Brenna Clark, partner at Eversheds Sutherland. Thank you. You may begin.
Hello and welcome to our webinar on post-merger benefits integration. My name is Brenna Clark. I'm a partner in our employee benefits group here in Atlanta at Eversheds Sutherland. And I'm joined today by my colleague Brittany Edwards-Franklin. She's an associate also in our employee benefits group here in Atlanta. So obviously Brittany and I are attorneys, so we approach things from a more legal perspective. And we work on both the deal side of benefits, so we'll be doing diligence and negotiating agreements up front, but we also do quite a bit of work on the back end and actually integrating benefits after a deal has finished. And so today we'll obviously be talking about that back end, the post-deal benefits integration. And we're joined today by our friends from Milliman, and I'm going to turn it over to Brett Linton to talk a little bit about Milliman and what they do.
Great. Thanks, Brenna. My name is Brett Linton. I'm a principal at Milliman, and I lead our mergers and acquisitions practice for the Employee Benefits Department. Milliman is a benefits consulting firm, and we do a lot of work in the mergers and acquisitions space, as does Eversheds, where we work through due diligence, day one readiness, and post-merger integration, valuing, designing, and integrating benefits programs, and integrating employees. Again, we'll focus on post-merger integration in this topic. I'm joined by my colleague, Paul Socrani, who is a health and welfare employee benefits consulting actuary in our Milliman Atlanta practice, who works on employers from anywhere from 100 lives to as much as a couple 100,000 lives, doing traditional actual work such as pricing, reserving, budgeting, and forecasts, and also works with clients in mergers and acquisition transactions, medical RFPs, and overall strategy. So I'll go ahead and kick it off here on slide 3. So here's what we'd like to accomplish in today's webinar, and that is to provide an understanding of the landscape around benefits as it relates to transactions, focusing on health and welfare benefits, non-qualified plans, equity arrangements, and other benefit programs. We'll then talk about opportunities and risks that might present themselves and things to consider when starting to think about harmonization. And then we'll cover implementation and communication. So with that, I'll turn it over to my colleague Paul to take us through slide 4.
Thank you, Brett. Hi, this is Paul Socrani. As Brett mentioned, I'll be providing some insights and considerations around mergers and acquisitions from a benefit perspective. However, given my background, it will primarily be from a health and welfare view. And so when we look at mergers and acquisitions from a benefit integration perspective, we typically like to break the process down into 3 phases. The first phase is understanding the landscape, and the goal of this phase is to help level set all of the parties involved by providing an overview of what to expect, as well as give us the opportunity to learn about the company's benefits and the merger itself. In this phase, we would also potentially identify some of the risks and considerations that may come into play with the harmonization of benefits. The second phase is the evaluation phase and the harmonization phase. In this phase, we would explore the integration of vendors as well as integrating the plan options and what some of the risks are. During this phase, we would also explore some of the potentially new strategies and cost-saving opportunities and how it may impact the company and its employees. The third phase is the implementation and communication phase. At this point, all the decisions have been already made and we can begin the harmonization process. The goal of this phase is to make sure that the harmonization goes smoothly with all of the vendors and the employees, and that we're satisfying all of the legal requirements. So with that, let's dive into understanding the landscape. So when we're going through a mergers and acquisition, we find it helpful to get a high-level overview of each company, as this will help with the integration process. Typically, during a mergers and acquisition, since there is a lot of uncertainty, most employers tend to try to minimize the changes and impact to employees, especially in that first year of transition. So on this slide, we put together a small list of questions that you may want to think about as you go through a merger and how it might impact the benefit integration. Say, for example, understanding why the companies merged. So what this tells us, if a company merged because it wanted to gain market share or expand into a new region, then most likely those two companies that are merging may already have similar type of employees and talent, and that means they'll probably also have similar type of benefits. So under this scenario, hopefully the integration process would be a little bit easier, especially when you're comparing it to a scenario that has two totally different companies. Other considerations or questions to think about that may impact the integration is around the type of employees that each company has. So for example, if there are any part-time employees, hourly employees, variable employees, or even seasonal workers, these employee classes may have very different requirements and eligibility rules, so you want to pay particular attention to them. Similarly, also around union groups and retirees, these are another set of employees that would have that you might want to pay particular attention to as well, because they may already have contracts in place that could limit or impose certain restrictions on how their benefits are integrated. Another thing that you probably want to think about and understand is, are there any liabilities on the financial statements? So if you're looking at the financial statements, there usually is going to be an IBNR and potentially an OPEB liability. And then lastly, one of the most important things in understanding the landscape around the harmonization or integration is getting a good grasp of each of the company's overall benefit strategies, as this is going to be the building blocks for the harmonization of the benefits. So on this slide, this gets a little bit into understanding the benefit strategies for each company. When it comes to mergers and acquisition, there is usually limited opportunities to work with both of the companies at the same time, and often there's going to be limited access to data or information. This is more of a problem on the pre-due diligence phase, but can also happen on the post-due diligence and integration phase. And so we tend to rely on the data to help us get an initial understanding of the benefit strategies for each of the company. So on this exhibit, we have a side-by-side comparison of each company's benefits. Currently, this is filtered on the medical plan, but the overall process and considerations for the other benefits would be similar. On here, we have Group 1, who is in blue, and Group 2, who is in green. So starting on the top left of this exhibit, there are a couple of key metrics we would really like to understand, such as how many employees are there, what is the total pay, what is the total compensation, then really how much does benefits represent from a total compensation perspective. From there, we would move over to the map, and the map helps us understand which regions employees reside. So the darker the color, the more the populated those regions are. And so this would help provide insights as to who may be an appropriate vendor of choice to invite to a given RFP, and maybe if there's potentially any regional vendors to consider. It also gives us a quick snapshot to identify if there's any overlapping populations where there could be potential consolidation that goes on. On the right side, it gets into the plan elections and the overall subsidy levels. This is really important as it helps us identify what plan options employees are currently offering today and how they are electing benefits. Typically, the most common plans today are going to be your PPO plans and your high deductible health plans, which operate very differently. And we will get into those plan options and some of the considerations around them a little later in the harmonization phase. Another really important item is understanding the subsidization of benefits. So does the company subsidize its benefit through richer plan designs, or is it subsidizing it through payroll contributions? This is illustrated by the two donut charts in the middle right, and also around the company subsidization is reviewing the employee contributions. What we would like to understand there around the contributions is how much each of the companies are charging their employees for the benefits, which could be illustrated on the bottom right in the stacked charts. Overall, these components are critical to the harmonization phase, as this will provide the starting point for integration. As we mentioned, this is simply a snapshot, but as you are learning the landscape, this is a type of information that you want to look at, probably with different slices, So for example, you might want to look at a particular group or a particular job class to get a good overall understanding of the company's benefit programs and overall strategies. And so with that, I'll pass it now over to Brianne, who will discuss and talk about the understanding the landscape from a compliance perspective.
Thanks, Paul. So yes, we're going to talk a little bit about maybe some legal issues that you might see when you're evaluating benefits and trying to get a sense of what benefits both companies have. I think while Paul focused on the welfare side of things, we're going to focus a little bit more on the qualified plan, non-qualified plan equity piece, simply because I think, there we tend to see a few more compliance-related issues. And so from a compliance standpoint, I guess we'll start with qualified plans. A lot of this, sort of understanding the landscape with retirement plans, a lot of times we'll start doing this in the due diligence phase, so even before the deal is done. We'll be gathering documents and trying to get a sense for where there might be issues. When it comes to compliance, we have a couple different types. There could be issues with the actual documents themselves, which I think is what we're typically trying to figure out in the diligence phase. And then we can also have operational issues, which I think we find tend to come up more often after the deal when we're starting to try and integrate everything. So what we would typically look for, we look for any types of errors. Are you operating in accordance with the plan document? Have there been any big underpayments to participants, missed contributions, all sorts of things like that? Are you letting the people who should be participating in the plan participate? So we would try and get a sense for where there have been errors and then whether those errors can be corrected. The IRS has some programs where you can correct errors, so does the Department of Labor. And the big issue here is, really what we're trying to decide with retirement plans is we're typically trying to decide whether you want to terminate one or the other retirement plans, if you can, whether you want to keep, sort of two separate retirement plan structures going, or whether you want to ultimately merge these plans together and create sort of one benefit plan for everybody. And so assessing these compliance errors is really going to help drive that decision. If you, for example, if you let's say you're the buyer and you have a seller plan, if there are a lot of compliance issues with that seller plan, then what may make more sense is to keep two benefit plans going forward, so that your plan with a lot of compliance issues doesn't, we call it tainting your good plan, so that if the IRS or the Department of Labor ever comes in and wants to audit those plans, then you've got at least one clean, we'll call it clean plan without any major issues. So that's one thing that we're looking at. We also might look at your data sufficiency and whether or not each plan has the ability to recreate benefits. I think this is particularly important for pension plans. Do you have data going back many years so that if you have participants coming forward and challenging their benefits, are you able to recreate that and show that? If that's something that one plan can't do, then again, it may make more sense to sort of separate out those compliance issues and keep the two plans separate ultimately. And then another thing that we look at is just the qualification status of the plan. And I think this is particularly important just because the IRS has recently mostly done away with its determination letter program, which is essentially a program where the IRS comes out and blesses a qualified plan and says that it complies with all of the relevant tax code requirements. So right now the IRS is not issuing any new determination letters. So I think it's particularly important to take a look at what has happened to the plan document since that last letter, if there's been anything unusual. Do you have one company doing something crazy with one plan that the IRS hasn't approved? That's just another thing that's going to play into your decision as to whether you want to terminate the plan, keep it, or ultimately merge two plans together. Some of the other things we might be looking at would be plan eligibility, so who's going to participate in what plan. The IRS has some non-discrimination rules around allowing people into plans. It's called coverage testing. So typically you just want to make sure that if you have one plan and you're keeping people out, you want to make sure that you're not keeping out too many non-highly paid people and letting in, a much larger proportion of highly paid people. And so, with a deal, you may have some new makeup of employees. Your ratio of highly paid employees to non-highly paid employees may have shifted in the deal. So it will be important to look at that again. And then a couple of other things, I'll go through this quickly, just that we tend to look at. We'll look at, is it even possible to make any mid-year changes? Under some plans, there are restrictions over what you can and cannot change mid-year. For example, in maybe a safe harbor 401k plan, or a plan where participants might have already accrued some benefits mid-year. We'd want to take a look at that. And then for defined benefit plans, one thing that we'll typically look at is the funding status. And this is particularly important if you have two pension plans and you're trying to decide what to do with them. Is one plan overfunded or underfunded? And what is it going to do to the funding status if you merge them together? And funding status is another thing that we look at from a standpoint of whether or not we should be terminating plans. And some of this will be on the 5500 and then the plan's financial reports. But just one thing that I wanted to note is that some funding analysis that we see related to the 5500, that may not be what the government says you need to fully fund and terminate your plan. So those numbers can differ. So that we'll tend to look at both of them. So that's an overview of what we typically look at from a qualified plan standpoint. If we're looking at other benefits like non-qualified plans and equity arrangements, typically where we'll find these type of arrangements is in, some severance arrangements. We may be looking at equity plans, your traditional non-qualified deferred compensation arrangements. And we can also see, some provisions in employment agreements, maybe retention agreements, change in control agreements, any sort of agreement that you might have with an employee. And what we're typically trying to do here is we're really trying to figure out what types of arrangements are out there. And so we can see what you want to keep, maybe what you don't want to keep, and also what you have to keep. Because a lot of these agreements could end up being subject to Internal Revenue Code Section 409A. And so I won't get too deep into that here, but Code Section 409A is a very detailed section of the code that has a lot of harsh penalties for executives if you are not operating exactly in accordance with your documents and according to a strict set of rules. So to the extent that these arrangements are subject to 409A, then there are a couple of things that come into play here. The first is that you may not be able to get rid of these arrangements or change them. Under 409A, what we see is these types of arrangements have fairly strict payment terms. They typically have a fixed payment timing. So, for example, if you've got some arrangement that says it's going to pay out at termination of employment, then we cannot just come in and change the arrangement and pay out this employee at some point before he terminates employment. So there are restrictions like that. There are also restrictions on your ability to change or substitute awards. Under 409A, what we typically cannot do is just say, all right, this employment agreement is with deferred compensation provisions is no longer in place. We've canceled it. We're going to put in something new with completely different payment terms. That is not something that is allowable under 409A. So typically what we're doing in this understanding the landscape phase is just trying to figure out what there is, trying to figure out whether these arrangements are subject to 409A, and then what can be done to either revise them, keep them under 409A. Another thing that we will do with 409A is just figure out whether there are any compliance issues, just because there is a fairly limited window of time to correct any 409A issues under the IRS's correction program. It's typically limited to the end of the second year after an error occurs. And the longer it takes you to correct something, the more burdensome these corrections become. So we typically try and get out in front of any compliance issues and address those before we get too deep into the integration phase. And then just the last thing that we're looking at is contractual provisions. What rights you even have to make a unilateral change to benefits, what you need employee consent for, and just, does the contract provide for any specific payout triggers or benefits or anything like that. And so with that, I think I am going to turn it back over to Paul to talk a little bit about the harmonization phase.
Thank you, Brenna. So the next phase is the evaluation and harmonization phase. So during this phase, you would be evaluating the financial and employee impact due to the harmonizing of the benefits. So there are many advantages and cost-saving opportunities when a company merge, but also some potential risk. And so one of the biggest advantages from a mergers and acquisitions from a benefit perspective is the increased population. This allows the joint companies to take advantages of the economies of scale. So there's a couple of reasons why this is important. The first reason is that with the larger size, the companies should be able to renegotiate their contracts to get a lower premiums for their ASO contracts or any of their fully insured arrangements. However, the more important reason is that with the increased size, it allows a company to explore and adopt new strategies. And so some of these strategies that a company post-merger should be thinking about are, so one, if you're currently offering fully insured benefits, you may be large enough now to go self-funded. So going self-funded has the added risk in which you would be responsible for your own employees' claims. But most likely, if you are large enough, this is going to be a less costly option than fully insuring. Second, if you're currently self-funded today, but you're utilizing a stop-loss, then you can consider increasing that stop-loss limit. However, as you review the different thresholds, you need to understand the overall risk that the company is taking, and you want to make sure that the level that you select is appropriate for your company's risk tolerance. Another area that the companies should consider is reevaluating its vendors. This process is typically done at least every 3 years by most employers as the markets are constantly changing. However, the reason why this is more important for a post-merger is because the joint company now may be able to adopt a new network strategies. So for example, with regards to the medical carriers, with the increased size of the joint companies may be able to implement something like a best-in-market approach, or they may even have enough employees concentrated within a given geography that potentially a regional player may make sense, or even an on-site clinic. On the pharmacy side, pharmacy costs are becoming a bigger component of the overall healthcare spend, and like the medical vendors, there is constant changes in the pharmacy space. And so many companies today are actually looking at their PBM contracts on an annual basis just because there could be some substantial savings over there. The last thing that I would mention is around understanding and benchmarking your cost drivers, and this way you could identify potentially any other programs that may benefit your joint population. And so these are only a couple of the strategies you may want to consider post-merger. However, with any of these strategies, you always want to determine what the financial risks are as well as the employee impacts. So for example, one of the risks associated by switching carriers is the impact to its employees. And so when you're evaluating the different carriers, you also want to make sure you're conducting a disruption analysis. And what a disruption analysis will do, it will help you understand how your employees are going to be impacted when you make that switch. And so the next step in the evaluation phase is really the harmonization of the benefits. So we briefly discussed about the current state and some of the considerations around harmonizing the vendors and new strategies. On this slide, I'll primarily focus on the actual harmonizations of the plan offerings itself. And so careful consideration needs to go into the harmonization process, as there is going to be a lot of uncertainty, and it makes it difficult to predict how employees may be electing their benefits under the joint or integrated program. And so with this uncertainty, it adds to the overall company financial risk, which is what we're trying to minimize or avoid. And so when it comes to harmonizing your medical plans, we often like to start with each of the company's original options, since the employees are already accustomed to those benefits, and it will help minimize any shock to the programs. And so when we're thinking about the different type of medical plan options, there are a couple that come to mind quickly. So you have a PPO plan, you have a high deductible health plan, you have an HMO, and each of these plans will act and behave very differently. So when it comes to like a PPO plan, most employees are already familiar with this plan option, and it generally does not pose too much concerns. However, with the PPO, those plans are typically going to be richer in nature when compared to a high deductible health plan, and so it will most likely cost the company more money. With regards to a high deductible health plan, this plan has been growing in popularity with employers. However, as the name suggests, these plans do have a high deductible or really a high cost at point of service. And so one of the potential risks when you're considering a high deductible health plan that you want to avoid is having your employees ignoring getting care because of the high point of service cost, and then later ending up with a catastrophic event. So there are definitely certain actions that you can take to help prevent this. So that's going to be a whole other topic on its own, so we won't go there. Another potential concern that you want to pay attention to when harmonizing the plan is when you're setting the employee contributions. So typically what you would want to do is determine the appropriate level to set the company cost share in aggregate, and then determine what that spread should be for each of the plan options. So incorrectly setting the contribution spread between the plan, this can lead to significant unexpected financial consequences, and this will expose the company to more risk than anticipated. However, similarly, this risk can also be mitigated with appropriate techniques. Then another potential financial risk that you want to be aware of when you're harmonizing your benefits is how you determine and set your overall premium and contributions by plan. So depending on the approach that you're using to set the overall premiums and contributions, this could lead a plan to enter what's known as a death spiral or a rate spiral. If this happens, it ultimately makes the plan no longer a viable option for your employees. So you just want to be careful on how you set the overall premiums and the contributions for a given plan. Then similarly, in the harmonization of the vendor process, as you go through the process of harmonizing the plan options, it is helpful to understand how employees are going to be impacted. And so we would recommend doing a winners and losers analysis that will compare the employee impact from a pre-merger state to a post-merger state. And this analysis should help demonstrate how much more or less employees may be paying from both a payroll perspective as well as a point of cost service perspective. So with that, I primarily focus on considerations around harmonizing the active programs. However, Brett is going to talk and discuss a little bit more about the OPEB liabilities, as this is or could be one of the biggest risks from a health and welfare perspective.
Great, thanks, Paul. One of the things I wanted to mention is in keeping in mind when you come across a post-retirement medical plan, sometimes also known as an OPEB plan, these plans are becoming less common, but there's still many of them out there. The primary difference with these plans, as you may know, is having to book a liability on the balance sheet for the present value of all future expected claims that are subsidized or covered by the plan sponsor. Obviously, a big part of the due diligence efforts is to verify that the balance sheet liability for these plans is accurate and that there aren't any hidden risks or costs that will be exposed down the road. But these plans can be tricky as well for other reasons. In theory, plan sponsors can terminate these plans at any time. However, they can be very litigious and therefore costly. Sometimes the benefits for these plans will summit or they'll go away at a certain date or a certain age. And if that has not been properly communicated by the prior employer, or even sometimes it may seem that it has, participants may still be expecting those benefits to continue. And so keeping proper documentation, as Brenna discussed earlier, is critical to avoid any kind of legal actions or preempt them, and also preventing the plan sponsors from taking potentially on more liabilities or having to extend the dates of coverage for those plans. But there can be opportunities as well with these plans. Pulling these plans into the current network may create a large enough population to self-insure now. And whereas maybe for the actives it doesn't make sense to self-insure, but for the retirees it could be, because these plans can be fairly large. And along with that comes with better negotiation power for discounting, for deeper discounts with carriers, et cetera. So they can prevent some opportunities as well. But in looking at some of these plans and options, it's good to assess historical claims experience and demographic data so that you know what you're dealing with. Doing this will help you understand some of the risks and exposures, as well as help you understand what the potential opportunities that may be available with these types of plans. So with that, I'll turn it back over to Brittany to take us through the next slide, slide 11.
Thanks, Brett. So, in addition to harmonizing health and welfare plans, once you have evaluated your benefit offerings, you may have interest in merging your 401k plans. This type of plan merger can result in vendor cost synergies. You won't be paying to maintain two plans potentially on two different platforms with different record keepers and different service providers. Combining the assets may make a single plan eligible for lower investment expense ratios. And there's also just less administrative hassle, which has its own costs, things like filing multiple sets of 5500s, multiple sets of participant notices, potentially participant confusion whenever employees are talking to each other, realizing they participate in different benefit programs or have benefits scattered, potentially retirement assets scattered across multiple plans. So with that in mind, whenever you move to merge a seller's plan, the first step you would look into are 401k protected benefits. And these are benefits, they're features that are offered in the seller's plan that have to be maintained in any plan those assets are merged into. If the money is taken directly from the seller's plan and put into a subsequent plan, as opposed to participant-directed rollovers where the protected benefits can be eliminated. So assuming a plan merger, you would want to evaluate distribution timing. Are there opportunities in the seller's plan to take distributions while the participant is still employed? Things like age 59 and a half distributions, the ability to take a distribution of rollover after tax monies at any time. Those are protected benefits, and so to the extent that money is merged into your plan, it will have to be accounted for separately, and it will have to be available at those times in your plan as well. This does not apply to hardship distributions or loans, so those are relatively easy to harmonize as far as merging assets. Other things that can be protected benefits are distribution forms. Generally, in a 401k plan, most distribution forms that are offered in a seller's plan can be removed as long as your plan offers a lump sum distribution. If you happen to have money purchase pension assets that were merged into the seller's plan previously, you will have to continue to offer annuity distribution forms. And so that's always something I like to find out relatively early in the process. Do we have any money purchase pension assets that have been merged in at some previous date? Disability retirement can get tricky if the plan provides for disability retirement. You might want to talk with your ERISA counsel just to make sure that the definitions of disability can be synchronized. And then normal retirement date and early retirement dates from the seller's plan would need to be maintained in the new plan. Often there we'll just go with whatever the earliest date is. It doesn't have a huge impact on 401k plans. Another area that you'll want to evaluate carefully is the definition of compensation, particularly if you're still using the seller's payroll processing or payroll platform. Then the payroll codes can be difficult to line up. Generally, whenever a plan sponsor is establishing their 401k plan, they make a number of judgment calls on what payroll codes are in and which ones are out of their definition of compensation. So as a result, you would want to carry those over to the compensation that's being paid to employees who are participating in the seller's 401k plan. Areas where we see this get tricky can be things like disability paid by third-party providers, taxable fringe benefits, bonuses, taxable life insurance, stipends, that sort of thing. As well, similar issue, loans. If you are merging a seller's plan into your plan, there will very likely be loans available in that plan, and they will be automatically merged over into your plan. It can be difficult to maintain the original amortization schedule for those plans, or for those loans. So it's important to take a close look and assess what you can do to make those continue to work. Beneficiary designations, if you're merging, generally a participant's beneficiary designation will automatically carry over into your plan. It's important to take a look at those forms. Sometimes they will have default rules on them that could conflict with your plan. Things like, if you don't make a beneficiary designation, or if your beneficiary predeceases you, this will be the default beneficiary. That can vary between plans. So you want to take a close look. You may need to notify participants that a different default rule applies than what was on their form originally. As Brenda mentioned, there can be mid-year changes to safe harbor plans that can be difficult to implement. If you're dealing with certain types of safe harbor plans, you may want to make those changes at the beginning of a year. Same with record keeper transitions. That can take several months to get accomplished, and you might want to check for termination notice provisions for the seller plan record keeper. It's not uncommon in this process, while you're evaluating and preparing to merge plans, to uncover operational failures. This is often when they come up, where you'll notice, hey, I see this provision in the plan, but the plan isn't being operated that way. Fortunately, the IRS correction procedures for qualified plans allow for a special correction window with respect to what they call transferred assets. So if you identify an operational error with respect to the seller's plan, you have 1 year from the date of the transaction to correct it, and you can do a self-correction generally there. You wouldn't have to file a VCP and go to the IRS and ask for their sign-off on the correction. So that's kind of a special correction window in the event that you find that. On investment piece, you just want to make sure that you are transferring investments in a way that preserves the safe harbor, the ERISA 404C safe harbor, which applies and says, to the extent that participants are selecting their own investments, they will be a fiduciary with respect to those investments. And whenever you're doing mapping or that sort of investment switch from one set of investments to another, there are certain requirements you want to follow to make sure that you've preserved that participant direction. Just a few other benefits that I want to touch on. Severance benefits. It's important to evaluate the severance benefits that are available to both groups of employees. If you're reorganizing and expecting that there might be a reduction in connection with the merger, it's an important time to evaluate your severance plan and amend it before any of those reductions take place. This can also be governed by the purchase agreement, so you want to keep an eye on that. The payroll transition is an important thing as well. Switching payroll systems generally, generally it's helpful to keep new employees on their existing payroll platform for at least through the first calendar year. Otherwise, you're going to have to track Social Security and additional Medicare and transfer all of that information over into your payroll system to make sure that you're withholding correctly from their pay. Non-qualified plan elections, if you have a merger and executives become newly eligible to participate in your non-qualified plan, there's a 30-day window where they can actually make elections, even in the middle of the year, so it doesn't have to be done in advance like we usually think of for those executives. So that's a great opportunity. On the retirement benefits, that's really, when we're talking about pension plans, you may want to evaluate whether it makes sense to go ahead and freeze any pension plans that you acquire in a merger. And then finally, last piece, cafeteria plan elections. If you're looking at terminating a cafeteria plan, I'd take a look at the plan document and look at whether it offers a grace period or a carryover. If it offers a carryover, which is the opportunity to bring $500 into the next plan year, but you're going to terminate it anyway, maybe you want to amend that to allow a grace period so your employees get a little bit more time to use up that money instead of just having it cut off. So with that in mind, I think I will pass it off to Paul to talk a little bit about implementation.
Thank you, Brittany. So the final step when harmonizing and integrating your benefits is the implementation and communication phase. At this point, you have already performed your vendor evaluations, you've determined what plans you're going to offer and the overall subsidy levels, and now is the time to bring it all together. So typically with a merger, there's going to be significant changes for your employees throughout each of the companies, and so effective communication is going to be very important to help with the overall morale and reduce any uncertainty and anxiety that your employees may have. And so we would suggest hosting open enrollment meetings where you can discuss these changes with your employees so they can get comfortable with the new options. This is also a great time to provide them with the educations around any of the benefit programs as well as answer any questions that they may have. In addition to the open enrollment meetings, it's important to make sure you have a thoughtful benefit guide to help your employees through the open enrollment process. Another big step around the harmonization of the benefits is the implementation process and the integration with your vendors. So if there's going to be substantial changes, you want to make sure that your portals and all your systems are tested. So for example, if you're reviewing your eligibility portal, you want to make sure that the employees are being offered the correct plans with the appropriate vendors. You also want to make sure that the employee contributions and the plan designs are loaded in correctly, etc. And so after the implementation is done and you have begun the new plan year, there is still some due diligence that you want to do to perform to make sure that your benefits are performing as expected. And so you may want to consider doing potentially a claims or eligibility audits to ensure that the plans are being adjudicated correctly, that only the eligible members are being enrolled in the plans. It may also be helpful to do a post-enrollment analysis as there was a lot of uncertainty and we're not sure how people may elect. And so this will provide you with an updated financial estimate for the upcoming year. And so I'll pass it back to Brittany, who's going to wrap up about some of the legal considerations around implementation.
Thanks, Paul. And you're exactly right. Communicating retirement and various benefit changes is really important. There are a lot of legal notices depending on how the structure is going to change, and sometimes it's helpful to provide them all in one packet so employees aren't receiving kind of piecemeal communications, but that's something that will really vary depending on what changes you'll be making for the employee group.
And similarly, you're going to be communicating this to employees, but there are also some required communications to third parties as well. If you've got a pension plan that is at all involved, oftentimes there may be some events that you need to report to the Pension Benefit Guarantee Corporation. A big one we see is 5500 filings. If you're terminating any sort of plan, then there is often a quicker time frame for filing those 5500s, so we want to make sure that we don't miss that. And also, when you're combining your health and welfare plans, you'll have to take a fresh look at exactly what is a plan and what are you filing a 5500 for. And then, of course, you're going to need to terminate any contracts with your existing vendors to the extent you're changing them. And then the final point we have here is just once you've implemented all of these, you're providing benefits to everybody, we'll need to take another look at the demographics and see, do we need to worry about any non-discrimination issues. And so with that, we are at 1:45. So I know that we had planned to let you all go at 1:45. I think to the extent you have questions, we are happy to answer them. I think you can email any of us, and we will make sure that your question is answered. But thank you very much for joining today, and we hope that you found it informative.